Excellent. Right, for part 4, and we've got some background music, which is even better. I do like this, it's picking up, I don't want to go through it again. So, part 4 is about juveniles, children, young persons in court cases and inquests, associated reporting restrictions. So, we're going to go over probably some same kind as section 3. So, 4.1, the age of criminal responsibility, including a child aged under 10, cannot be prosecuted, and what the term juvenile embraces, which is anyone under the age of 18. Juveniles charged with a crime are in most instances dealt with in youth courts, but that some juveniles may be tried, sentenced in the adult courts, magistrates' court or crown court, if there is an adult who is co-accused, or appeal as a sole defendant in the Crown Court if the alleged offence is serious. That Section 49 of the Children and Young Persons Act 1933 imposes automatic restrictions which forbid the identification in any publication of a juvenile as being concerned in the proceedings of a youth court case, and a definition which includes juvenile defendants, juvenile witnesses, and juveniles who are not witnesses but who are the alleged victim of an offence. So that's the important bits highlighted. I don't know. Sometimes I forget what my notes mean. That the restrictions scope is that no detail should be included if it is likely to identify the juvenile as being concerned in such proceedings, and what, as regards scope, the section says in detail, which in particular should not be included if likely to identify such a juvenile. Section 49 lists these items as the juvenile's name, their address, the identification of any educational establishment they attend, the identity of any place of work, and any still or moving picture of them. And that restrictions automatically apply to media reports of appeals heard in higher courts from youth court decisions. 4.3. That a youth court may lift the Section 49 anonymity in respect of a convicted juvenile if there is a public interest justification. That the youth court must hear representations from parties, their lawyers, before deciding whether to lift the defendant's anonymity on that ground, and should also consider representations from the media, arguments that journalists can make, drawing on official guidance to the youth court about why it is particularly appropriate for the court to use this power to remove a defendant's anonymity in some circumstances. So Section 49 states circumstances for lifting are for persistent or serious offending. Offending had an impact on a number of people. Alerting people to their behaviour would help prevent further offending. And situations where it shouldn't be, where publicity might harm the offender or their family, where the offender was particularly young or vulnerable, where the offender was contrite and ready to accept responsibility for their actions, when public identification of the offender would lead to the identity of a vulnerable victim. That in any event, the automatic anonymity under Section 49 ceases to apply for any juvenile concerned in the proceedings when she reaches the age of 18. Okay. But that the youth court may, in circumstances, use Section 45A of the Youth Justice and Criminal Evidence Act 1999 to give lifetime anonymity in media publications to such a juvenile, with the exception of any defendant. Read that again. Lifetime anonymity in media publications to such a juvenile, with the exception of any defendant. See subpart 4.5 of this program. That's coming up in a bit. 4.4. That in criminal proceedings, a magistrates or Crown Court can use its discretion to make an order under Section 45 of the Youth Justice and Criminal Evidence Act 1999 to provide anonymity for a juvenile concerned in proceedings as defined above. That the restriction's scope is that no detail should be included in any publication if it is likely to identify the juvenile as being concerned in the proceedings, and what, as regards scope, the section says is detail. The section says in detail which in particular should not be published if likely to identify such a juvenile in this context. This is a list of items again. So Section 45 lists the juvenile's name, their address, the identity of any educational establishment they attend, the identity of any place of work, and any still or moving picture of them. That under section 45, the anonymity ceases to apply for any such juvenile when he/she reaches the age of 18, as per section 49. That the act says for a ground for challenging the imposition or continuation of such an order, or for arguing the relaxation of its scope, is that it imposes a substantial and unreasonable restriction on the reporting of the case, and that it would be in the public interest to remove or relax that restriction. Yeah. That the definition concerned in the proceedings includes a juvenile in respect of whom the proceedings are taken, and so section 45 could validly protect the identity of a juvenile in a case in which his parent is prosecuted for failing to ensure he/she attends school, even if the juvenile is not a witness. Okay. Section 4.5, which we referred to a minute ago, that a criminal court can, under section 45A of the Youth Justice and Criminal Evidence Act 1999, make an order that no publication should identify a specified juvenile who is a witness or the alleged victim, as being concerned in those proceedings. That the normal scope of this anonymity is that it lasts for the juvenile's lifetime, and that no identifying detail must be published. Key here is its lifetime. This one does not end at 18. So that's section 45A as opposed to section 45. And what, as regards scope, the section says as detail, which in particular should not be published if likely to identify the juvenile in this context. So surprisingly, that's name, address, educational establishment, work, and any still or moving picture. That the court can make a section 45A order if the juvenile was aged under 18 when the proceedings began, and the court is satisfied that the juvenile is in fear or distress about such identification, and the court is satisfied that the quality of her evidence or level of cooperation will be diminished unless there is this anonymity provision. That section 45A order cannot validly be made for a defendant, as stated. That the act says a ground for challenging the imposition or continuation of such an order, or for arguing for the relaxation of its scope, is that it imposes a substantial and unreasonable restriction on the reporting the case, and it would be in the public interest to remove or relax that restriction. 4.6. That in civil proceedings, a court can use its discretion to make an order under section 39 of the Children and Young Persons Act 1933, that no publication should identify the specified juvenile as being concerned in the proceedings. That this definition means a section 39 order can be made for a juvenile who is a claimant, defendant, or a witness in the county court or high court or other civil proceedings. Also, a coroner can make a section 39 order to provide such anonymity for a juvenile who is a witness in an inquest. The normal scope of a section 39 restriction, and would you believe it, the wording is slightly different here, but it's still similar stuff. The juvenile's name, their address, their school, any particulars calculated that would lead to identification, a picture of or including the juvenile. That such anonymity automatically ceases to apply when the juvenile reaches the age of 18, which has been confirmed by the Court of Appeal. Case law mentioned is easy to remember. It's R on the application of JC&RT, the Central Criminal Court 2014 Court of Appeal. But it's essential. 4.7. The case law and judicial college guidance is that the anonymity bestowed by section 49 of the 1993 Act, or provided by an order made under that Act section 39 or under section 45 of the 1999 Act, does not apply to dead juveniles. The ground of challenge to the imposition, continuation of section 39 or section 45 anonymity for juveniles is that case law and judicial college guidance say that there must be good reason for the restriction. And as a footnote, as noted in McNays on page 193, it is accepted that case law on use of Section 39 of the 1993 Act applies to use of Section 45 of the 1999 Act. See also the September 2006 update to Chapter 15, which notes that the latest version of the Judicial College guidance makes this point. And I've got notes to come back to this, so I guess I'll come back to that one. Let's see. That the automatic anonymity under Section 49 does not apply for any juvenile who is not concerned in the proceedings, and that any anonymity imposed under Section 39, 45 or 45A orders can be challenged as invalid if the specified juvenile is not concerned in the proceedings. That courts have accepted that alleged child victim may be too young to need Section 39 anonymity, and this case law can be cited to oppose Section 45 anonymity being granted or continued. Case law here is R versus Lowestoft, 2013. A mother was convicted of being drunk in a public place. The court refused to grant a Section 39 order for the 3-year-old child, a decision upheld by the High Court. The case law is that Section 39 or Section 45 should not be used to specifically give anonymity to adults. Case law here is R versus Southwark in 1991. The Court of Appeal ruled that Section 39 orders could not be used to ban the publication of the identity of an adult defendant. The names of the cases which can be cited for any ground of challenge referred to in this subpart of the programme, as set out in McNay's pages referenced above. And there are quite a few. Brilliant. So we've got Crawford v. Director of Public Prosecutions, The Times, 2008. This is where the High Court ruled that Section 39 cannot be used to spare the embarrassment of a defendant's children if they are not concerned in the proceedings. I think there's probably some more that I haven't bothered to put on. Brilliant. Anyway, and then the danger of jigsaw identification breaching anonymity provision for juveniles referred to in this part of the programme. So that's the plan. Let's have another break as we hit Section 5 halfway.